is not, the law lords have said, determinative. The text is not determinative. Rather, the courts will be constrained only, mark the word only by the underlying thrust of the legislation A and the limits of their institutional capacity. Now, Malas, the counter question, the devil's question, is posed in the next paragraph. This paper discusses Ghedan and its implication. It suggests that the remarkable aspect of Ghedan is that it simultaneously divorces the process of statutory interpretation under HRA from the twin anchors of parliamentary intention and statutory text. This I'm relying upon heavily, Malas, this first sentence. The second part, in that light, it is suggested that the dichotomy between interpretation and judicial legislation is at the very least under pressure, and the courts are in fact appropriating to themselves a significant, if nevertheless a subsidiary slice of legislative power. Now come to Malas page 8. Page 8. So, where did you write it down? Page 8. Of the four law lords in the majority,
Yes.
of the four, page 8, Malas, 8. Roman, big Roman 2. Of the four law lords in the majority, the names are given. All but the last delivered a separate opinion on the correct methodology under 3.1. There was, however, substantial agreement on these essential principles. Then the key issue, separating the sheep from the goats. Their lordships identified the key issue under 3.1 as being how to determine the limits of what is possible. The scheme of 3 and 4 of the treaty envisages that there is a Rubicon which the courts may not cross. What is not, however, spelled out is the test to be applied in separating the sheep from the goats. Parliamentary intention is not the touchstone. This is another red herring which your lordship may have to deal with in the present case. In investigating the line between the possible and the impossible, Lord Nicholas and Lord Stein held that the courts were not constrained by the intention of the parliament that enacted the legislation. Very, very important. Lord Nichols distinguished the required approach in this respect with the orthodox approach to standard statutory interpretation, which involves seeking the intention reasonably to be attributed to Parliament in using the language in question. In contrast, Section 3 may require a departure from that parliamentary intention. Departure from that parliamentary intention. The key question being how far and in what circumstances. This is because there is another and a countervailing parliamentary intention which needs to be given full weight. Namely, Malas, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Objective. Now, nor is the statute. The second thing which is not determinative is statutory text. And Malas, it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, Malas, it would be sacrilege to suggest this to an English court. Remarkably, their lordships held that the language of the statutory provision at issue is not the touchstone in deciding which it is not possible under 3.1. This holding had a number of dimensions. Further, their lordships expressed concern about excessive concentration in a literal or technical way on the linguistic features of the statute. Rather, Section 3 requires a broad approach, concentrating, amongst other things, in a purposive way on the importance of the fundamental right involved. So intention one way, statutory text one way. Now we've got a third test, importance of fundamental right involved. Secondly, their lordships stressed that the proposition that ambiguity in the statutory language is not a prerequisite to the operation of 3.1. Ambiguity is not your lordship's poll star. Thirdly, 3.1 might thus have a role even if the statutory language is not capable of bearing two meanings. Lord Nichols says, once it is accepted that 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose that Parliament intended that the operation of 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under consideration. That would make the application of 3 something of a semantic lottery. From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with a convention-compliant meaning does not of itself make a convention-compliant interpretation under 3 possible. So this is impossible. I'm sorry, impossible. So your lordship's ultimate guide star is intention, no. Text, no. Parliamentary, well, is overall purposive theological, no. But the ability to achieve a convention compliant result. A convention compliant result. Next page, Willis. At page 10, I'll just read the quotation. Fourthly, their lordships considered that 3.1 empowers the court, if necessary, to change the meaning of the legislation. This is actually the heart, the legal heart of this case is this, Willis, interpretation, how to look at these sections. 3 enables language to be interpreted restrictively or expansively, but a 3 goes further than this. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. It is apt to require the courts to read in words which change the meaning of this enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of both primary and secondary legislation. Their lordship's view is not the touchstone in determining whether a convention compliant reading of legislation is possible, begs the question. If not the words, then what? How then is one to sort the sheep from the goats? Their lordships identified 2 overlapping limits. So now he's answering the question, how do you separate the sheep and the goats? What is possible under 3.1? This is the first test, fellows. General thrust of the legislation. Second is court's institutional capacity, which is defined later on, coming out later. As to the first, their lordships held, 3.1 does not authorize the courts to adopt a meaning that is inconsistent with what they variously described as fundamental feature of legislation, underlying thrust of legislation, grain of legislation. Each of the footnotes gives the lordship the para. A cardinal principle of legislation, the very core and essence, the pith and substance of the measure. Well, is to take a 5-second aside. It is a kind of a basic features intra-legislation. Basic structure doctrine, intra-legislation. Right. These are very interesting developments. The lordship is... The tenor and the provision of the law. Exactly. That internal, does it make internal sense? It has to be intra. So you can't confine it to... Correct. Wow. This notion that the courts cannot turn, page 11, 11 top. This notion that the courts cannot turn the scheme of the legislation inside out overlaps with the second point, which is that the courts cannot make decisions for which they are not institutionally equipped. Now, what is the meaning of this? Some cases that lordships held call out for legislative deliberation. So if it's a case where a lordship finds the whole script has to be written, it has to go to the legislature. This might be the case, for example, if the exercise of making the legislation convention compliant would involve the substitution of a detailed statutory scheme. It's a very fair test, fellows, very fair test. Or if a policy choice needs to be made between different methods for achieving convention compliance, or if the decision would have far-reaching practical repercussions, the courts are not well equipped to evaluate. This has to go case by case, fellows, to your lordship's ultimate decision. Now come to 13, page 13, 1.3. In Ghaidan, however, lower part, second half of the page. In Ghaidan, however, the House of Lords rejects both a focus on text and a focus on purpose. I'm sorry, Justice Kohli doesn't have page 13, lower part. I'm just doing a little bit of speed reading, Your Lordship's permission. Now, Your Lordship, teleological purpose, Bennion. So even that is out. Both a focus on text and a focus on purpose. This creates something of a puzzle as to what their lordships might mean when they say that the interpretive possibilities created by 3 are limited by the underlying thrust, 1, of the legislation. Considered in isolation, that proposition might sound a restatement of the modern purposive approach to statutory interpretation. The purposive approach has, however, been explicitly rejected by their lordships. The intention of Parliament in enacting the relevant legislation must, they said, give way to the intention of Parliament in enacting. That the underlying thrust approach is not consonant with the purposive approach is manifestly evident from their lordships' analysis of the statutory scheme, page 14, top, at issue in Ghaidan itself. Lord Nichols postulated that the social policy underlying the extension of security of tenure in 1988 to survivors of de facto opposite sex relationships was equally applicable to survivors of de facto same sex relationships. On the basis of that essentially normative conclusion, he held that the underlying thrust, this is the test for us, the underlying thrust of the Rent Act of 77 did not preclude a convention compliant interpretation.
So then
The underlying
two parts. One is yes, this is how you make it consistent with the convention. The second is they abandon the purposive construction method.
and the textual and the intention based. Now, if your lordships were to find
Was it? Diametrically.
well,
It's
if there's a
your-
prohibition,
I'm just
I would
asking
say,
again.
I would
Yeah.
say, in fairness, the answer would be no.
Then
If the language is diametrically opposite.
interpreted to
No,
choices
the
of the
lordship
court.
is, when your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, there could be.
Prohibition.
We are looking.
Answer has to be no.
let us- let
I'm
us-
not here, Mulus, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on the basis of interpretation. Then your lordship may be able to override it for Mulus some second argument. It's not the only answer. Second answer is
But if
your
that
lordship
provision,
as not constitutionally compliant.
then when-
There are two ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just returned. Your lordship will then apply that test. The first test my Lord Justice Narasimha is asking me is intra-legislation. To that, the answer would be there's a prohibition, and I still ask you to only interpret. Your lordship may have
How can
difficulty.
we confine to that concept that if there is a prohibition, then only we say that it should go back to the legislative
right.
drawing board? Because
No, if it's not constitutionally compliant on the larger challenge, no, your lordship can strike it down.
because let me complete. We are looking, focusing our gaze on the only provision. In Gaidan, it was possible. Gaidan, the question was simple. And also Gaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them
Yes.
who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of.
Therefore,
Yeah.
Malas, therefore, two things. Ghedan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples
Given.
versus homosexual couples in the interpretation of that act. Number two, the question would be if your lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your lordship would go one way. If your lordship, however, to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my lord's query,
Preclude as-
does not preclude or exclude a same-sex couple, that's follows. Therefore, that choice ultimately
See,
follows the.
If presented the way Gaidan is presented, we have no difficulty. But if you take the steps in Gaidan, which is the internal sense of the enactment, then we will necessarily have to go into
The
other
two
provisions.
different acts. Lordship naturally. This is Ghedan is something
Then-
else. This is
then
something else.
Then
I'm only on the
the
approach.
route
to
which we may have to take is something else.
Well, I'm only giving your lordships a approach to
Yes,
interpretation,
you're right.
which should comment to your
It's
lordship,
quite a
obviously in a different context.
It's a
Obviously
very novel approach.
novel approach and a
But
different
having
context.
said that, here you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So
And
does the
therefore-
underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct? Is the
Because
case?
your principal premise is that when the legislation was enacted in 1954,
Yes.
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage,
Absolutely. Absolutely.
right? And not,
Special categories.
you are giving Parliament was intending to provide an avenue to people beyond
Beyond.
your religious, the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yeah.
There was
Yes,
an aspect of endogamy
yes,
which
yes.
we cannot ignore.
Yes, yes, yes.
So
yes.
it was, an all enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special
after
category.
1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable
That's
relationship.
because you go back and
Therefore,
say, yeah.
By decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law,
Lordship.
then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships
Let me put it
of
bluntly.
the same
I'm very
sex as
grateful.
well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
Way of
That
looking
makes
at
no
it.
difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends
As it
contemporary understanding to
It's an evolving,
comprehend-
dynamic concept.
to
Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later
Well,
developments.
I
It
don't want to.
transcends the existing.
I don't want to sound well. That is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new
Or
statutory
would
scheme.
yeah, exactly. Would the
New
court be
statutory scheme.
rewriting the entirety of the statute? Would the court really be making policy choices, which is for the legislature to make?
Lordship.
So long as we don't straddle that line, which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test
equally,
was
I
enough.
think the impact of
Put a
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore,
Lordship.
purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleologic and purposive also, which is supposed to be in
play
advance,
again-
falls back.
I'll play a little bit of a spoiler. Gaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years